Hello, everybody. So, before I get into today's video, I want to give a little prelude just to give some context as to why this video is much longer than my average video and why I'm talking about this. Well, this video is based on a paper that I wrote for my judicial politics class last semester. My topic was about judicial elections. Basically, should judges be elected? Yeah, I think that's pretty self-explanatory. So, why do I think it's important? Why am I making it into a video now? Well, the reason I'm doing it is because with the recent Supreme Court ruling of the Texas abortion law, we've seen renewed calls to pack the courts and all that. And this, I want to kind of I want to inject something into the political discourse that is a little bit different, talking about what can we do besides that. Now, I understand that something like what I'm proposing here, it's probably going to be harder to pass because it will require a constitutional amendment compared to packing the courts, which requires passage of legislation. But I still hope that this idea can gain some traction because it's already used in several states. And I'm aware that for this, I am talking primarily about state Supreme Courts. That's because when I wrote the paper, that was what I was focusing on. But I think on some level, it can be applied to the national level as well. Now, I want to clarify something. The Supreme Court is going to be political forever. It's going to have some political bias because all judges are biased. Everybody knows that. But how can we maintain judicial independence and to the greatest possible extent? That's the goal of this video. So, I want to have a discussion on this. I know this is going to be a long video. It's honestly like a short film. It's like a mini documentary. So, if you want to read it, if you don't feel like watching it, if you just want to read it, I have a link down below to where I have the document for this video. It includes all my sources and everything. So I hope you guys like it, and if you like the style of video and you want me to do more, like these more longer form videos, I'll do them every now and then. So yeah, just leave me a comment below letting me know what you think. And yeah, that's pretty much it. Hope I could put some things into context here. And yeah, grab some popcorn because you're gonna be here for a while. Although judicial elections have been used in U.S. states for decades, the idea of selecting state judges via direct election has been controversial, especially in recent years. Currently, the overwhelming majority of state judges in America are directly elected in some way, shape, or form. However, a large segment of the American public has questioned whether or not this method of judicial selection is just. Some say that it makes judges beholden to popular opinion, even if it means blatant disregard for the rule of law. Others, however, say it promotes judicial accountability as well as judicial independence. Knowing the arguments on both sides, it begs the question, are judicial elections a good way to select judges? Also, is a compromise between judicial elections and appointments a good strategy? Although public opinion on elected judges remains mixed, there is a lingering support for judicial elections, particularly in rural areas. The idea of judicial elections was first popularized during the Jacksonian era, in which supporters of President Andrew Jackson felt that if states give governors the power to nominate and legislatures the power to confirm judges, it would lead to them favoring nominees with whom they were close to, which Jackson and his supporters detested. This populist narrative still remains in rural districts, whose constituencies are more likely to be turned off by the political establishment. Other arguments used by supporters of judicial elections include that elected judges are the most independent in the nation, and that electing judges promotes accountability in addition to independence. Also, they believe that such a system is preferable to having judges appointed by the executive and confirmed by the legislature, as they would mostly pick nominees with whom they were close to, and not base their choices on qualifications or experience. However, opposition to judicial elections is rooted in the U.S. Supreme Court's ruling in the 2010 case Citizens United v. FEC, which ruled that limits on how much outside groups could spend trying to influence elections were unconstitutional under the Free Speech Clause of the First Amendment. Ever since the court handed down that controversial ruling, outside spending by interest groups and political parties has exploded, and judicial elections are no exception. Now, public opinion polls consistently show that most Americans believe that their state judges are not unbiased, which was the initial intent of having a judicial branch, but beholden to the corporate and special interests that spend big to help them get elected to the bench. Even pre-Citizens United, this has been proven, at least to a certain extent, by political science research. Additionally, with unlimited outside spending now permitted, interest groups ask judicial candidates a certain set of questions as to where they stand on the hot-button legal issues of the day, whether it be abortion rights or same-sex marriage, clearly judging whether or not to support their candidacies on how they expect them to rule on the bench, and not based on their judicial experience. Despite the aforementioned issues opponents of judicial elections have brought up, many of the same issues apply to judicial appointments as well. Outside groups spend big on trying to convince the Senate to approve or reject a Supreme Court nominee, and the president usually has a set of prerequisites regarding judicial philosophy and ideology that they want their judicial nominees to meet, similarly to judicial elections. Nearly 9 out of every 10 state court judges in the U.S. must stand for some type of judicial election. In recent years, spending on these elections has only grown. In 2004, candidates for a seat on the Illinois Supreme Court, in a rural district no less, raised a collective total of $9.3 million. That is more than the candidates in a majority of Senate races that election cycle raised. This high price tag can be attributed to outside spending on both sides, including from labor unions in favor of the Democratic candidate and the U.S. Chamber of Commerce on the Republican side. While state judicial elections were not initially subject to the influence of big money, that changed in 2000, when judicial candidates across the nation raised over $45 million in total, as well as at least an additional $10 million spent in outside spending by interest groups and political parties. This spending from these interests has led to the belief that, once they are elected, these judges will make decisions in the interest of their donors and not for the public good. A 2006 New York Times study on judicial elections in Ohio provides evidence to back up this claim. Quote, Ohio Supreme Court justices routinely sat on cases after receiving campaign contributions from the parties involved or from the groups that filed supporting briefs. On average, they voted in favor of contributors 70% of the time. In particular, Justice Terrence O'Donnell, during his re-election campaign in 2004, received campaign contributions from the PACs of 3 corporations that were defendants in class action lawsuits the High Court of Ohio was due to hear after the election. After winning re-election, O'Donnell refused to recuse himself from hearing these cases, which included 2 revolving around defective cars and 1 relating to a toxic substance, and he ended up siding with the corporations that gave to him in all 3 of them. This example is hardly an anomaly for O'Donnell, as he did not recuse himself from cases involving groups and companies that donated to his campaigns 91% of the time, significantly higher than the aforementioned 70% average for Ohio High Court justices, as well as higher than any other individual justice on the state Supreme Court. Additionally, the Times found that, in the 12 years of cases that were studied, judges recused themselves from cases in which they had potential conflicts of interests less than 5% of the time. Justice Paul Pfeiffer, a colleague of Justice O'Donnell, states that, quote, everyone is interested in contributing, has very specific interests. He also mentions that these campaign contributors are donating to judicial candidates with the intent to buy their support for them when they rule in cases involving them. In addition to Ohio, Supreme Court justices in states such as Illinois and West Virginia are guilty of these practices, with elected justices refusing to recuse themselves in cases involving coal, insurance, and tobacco companies that had spent money to help them get elected. This rise in spending can be attributed to many external factors, including the public's newfound interest in lower court decisions, as well as the increasing influence television advertisements have on elections. Interest groups that spend big on these elections generally create questionnaires for the judicial candidates to fill out. They prioritize their answers to these questions over the candidate's legal experience. For example, state chapters of the anti-abortion group Right to Life send questionnaires to get the word of judicial candidates that, should they be elected, they would vote to limit abortion access. Peter D. Webster, a Florida judge, has decried these questionnaires, claiming that they, quote, create the impression in the minds of voters that judges are no different from politicians, that they decide cases based on their personal biases and prejudices. Of course, nothing could be further from the truth. Despite Judge Webster's insistence, the U.S. Supreme Court has ruled that it is unconstitutional for the government to ban state judicial candidates from stating their positions on the legal issues of the day. In the case, known as Republican Party of Minnesota v. White, the court overturned a Minnesota Supreme Court ruling that stated candidates could not speak their positions on issues while running for judicial office. It was brought to the court after a candidate was caught breaking that rule by spreading literature that contained his stances on the issues. The concern that many voters have that popularly elected judges are beholden to their donors is further evidenced by the case Caperton v. A.T. Massey Coal Company. A civil jury in West Virginia found the company liable for $50 million in damages. The case was appealed to the state Supreme Court, and a judge that an executive for the company had spent $3 million to get elected refused to recuse himself from the case and cast the deciding vote in favor of Massey. Ultimately, the U.S. Supreme Court overturned the state's court ruling and declared that judges must recuse themselves from cases in which they have a financial conflict of interest. In his opinion, Justice Anthony Kennedy wrote, quote, "Under our precedents, there are objective standards that require recusal when the probability of actual bias on the part of the judge or decision maker is too high to be constitutionally tolerable. Applying those precedents, we find that, in all the circumstances of this case, due process requires recusal." Despite the High Court's ruling in this case, the initial instance of the West Virginia Supreme Court justice receiving money from the campaign whose favor he ended up ruling in only furthers public opinion that judges who are subject to elections are not independent-minded and only listen to their donors. Despite this, as well as the aforementioned study on the behaviors of Ohio Supreme Court justices, a separate analysis done by law professors on the decisions of the Wisconsin Supreme Court, whose judges are also chosen via direct election, do not show any noticeable favoritism towards their big money donors. Not only that, but they additionally found that judges who were subject to partisan elections end up being the most independent-minded.